We are on the record in the North Dakota Industrial Commission case number 32201. It's now 8:39 a.m. Case number 32201 is a motion of the Commission to consider amendments to the general rules and regulation for the conservation of crude oil and natural gas and geological storage of carbon dioxide, codified as Articles 43-02-03 and 43-05-01 North Dakota Administrative Code. Copies of the proposed rules are available on the table. Sign-up sheet is also on the table. Please sign up on the sheet if you want to present testimony or comments today. After these announcements, I'll be calling on people in the order on the sign-up sheet to come up to speak. This hearing, as well as the other hearings which will be held by the Commission this week, will be streamed live and can be listened to via the Department of Mineral Resources Oil and Gas Division website. The Industrial Commission is required to adopt administrative rules in accordance with North Dakota Century Code, Chapter 28-32. This administrative rules hearing is held pursuant to North Dakota Century Code 28-32-11. The purpose of this hearing is to ensure the public has an opportunity to provide their comments and submit data, views, or arguments before administrative rules are adopted. It is important to the administrative rules process that the public's comments are received and considered. If anyone believes their ability to participate in this hearing is hampered by a disability of any kind, please let me know so that I may arrange the means for you to fully participate in this process. Please remember that this is an administrative rules hearing and not a legislative or court hearing. The purpose of this hearing is to get input from the public, especially those who have not yet had a chance to be heard concerning these rules, or those who have not or will not have an opportunity to submit written comments. This is not a question and answer session. The purpose of this hearing is not to pose questions to the Commission staff about the proposed rules, but an opportunity for the Commission staff to receive input from you. Please try not to repeat testimony of others, but rather refer to previous testimony you agree or disagree with instead. I would ask that you start your testimony by stating your name, address, and the organization you are representing, if any. To make sure we understand the comments you are providing, Commission staff may ask you questions following your testimony. At the end of the hearing, pursuant to North Dakota Century Code 28-32-12, the Commission will have a written comment period during which data, views, or arguments concerning the proposed rules or feedback regarding today's testimony will be received by the Commission and made a part of the rulemaking record to be considered by the Commission. All comments received both today and during the written comment period will be given serious consideration by the Commission. All comments and correspondence must be submitted to the Commission prior to 5 p.m. October 31st and will be made a part of the record for this case. All comments received prior to today's hearings will also be made a part of the record for this proceeding. Comments received after 5 p.m. October 31st will not be included in the record. Brady, if you'd like to come up. I think you're good.
Good morning, Mr. Gardner, members of the panel. For the record, my name is Brady Pelton. I work with the North Dakota Petroleum Council, who collectively represents over 550 members involved in all aspects of oil and gas activity in North Dakota, South Dakota, and the Rocky Mountain region. Our address, for the record, is 100 West Broadway Avenue, Suite 200, located in Bismarck, North Dakota, 58501. And I think I covered all the required parameters there. So, Mr. Gardner, I guess I'll just open up with saying that the North Dakota Petroleum Council, which I appear on behalf of today, fully supports and appreciates the opportunity to provide comments to this rulemaking to the Industrial Commission and this panel. We look forward to answering any questions you might have at the conclusion of our testimony. Generally, North Dakota Petroleum Council is appreciative of the Commission's efforts to simplify, clarify, and streamline existing processes and its work to reduce the regulatory burden on the regulated community after review of policies and regulations that might not fit with modern day technology and advances there or best practices in the industry. We specifically commend the Commission for its continued work to update the North Star system and remain supportive of both updating the code to implement more reporting requirements within this unified system and any additional resources the update will require to make more user-friendly to the regulated community. We recognize and appreciate the Commission's intent to work collaboratively with the regulated community in advancing common sense updates that both protect the public and promote continued responsible energy development in North Dakota. Just for the record, Mr. Gardner, to formulate comments on behalf of the industry itself, NDPC has solicited input from its member companies and formed a technical committee to develop the attached comprehensive comments, which I believe everyone has a copy of now, on behalf of full membership. The committee has met to study, review, and adopt these initiative comments that reflect the opinions of our over 550 member companies, and they should be viewed as comments from the regulated community and not from one single entity. Also, I'll note that given the compressed schedule and the breadth and importance of the topics that we're here to discuss today, NDPC reserves the opportunity to offer further clarification and comments as necessary before the official deadline for comment submission on October 31st, 2025. And with that, Mr. Gardner, I will proceed with NDPC's formal comment. First, beginning in section 14.2, dealing with oil and gas metering systems, page 9 of the proposed rules. NDPC supports the efforts of the Industrial Commission to streamline the process by which a variance to the requirements of this section may be granted by the Director, allowing the Director to grant such a variance verbally while still requiring the variance to be filed on a facility sundry notice allows for flexibility on the part of meter owners without a loss of reporting transparency. Moving on to section 18, specifically subsection 2, subdivision B, dealing with drilling units and well locations. NDPC strongly supports the proposed amendment allowing larger drilling units for deeper horizontal wells. This amendment represents a forward-thinking approach to oil and gas development that recognizes the unique characteristics and economic considerations of developing deeper geological formations in North Dakota. The proposed change appropriately provides regulatory flexibility while maintaining the fundamental conservation principles that govern spacing and drilling unit requirements. The flexibility to establish larger drilling units for deeper horizontal wells serves multiple important objectives. It promotes the efficient development of North Dakota's oil and gas resources by allowing operators to optimize well spacing based on actual reservoir performance and characteristics rather than arbitrary depth-dependent requirements. It also encourages continued exploration and development of deeper formations that might otherwise be uneconomic under conventional spacing limitations, thereby maximizing recovery of the state's hydrocarbon resources. Finally, it reduces surface disturbance by potentially requiring fewer well locations to effectively produce from deeper formations, which aligns with responsible environmental stewardship. This amendment also demonstrates the Commission's commitment to science-based regulation that adapts to evolving industry practices and geological understanding. Operators have accumulated substantial data over the past decade regarding optimal well spacing and drainage areas for various formations at different depths. Allowing larger drilling units for deeper wells recognizes this technical knowledge while still requiring operators to justify their proposed spacing through the permitting process, ensuring appropriate regulatory oversight. NDPC commends the Commission for this proposed amendment and encourages its adoption. Moving on to section 19, dealing with site construction. The proposed amendment requires that, quote, sites exhibiting instability shall be reported to the Director immediately, end quote. NDPC requests clarification regarding what constitutes reportable instability. The term as currently written could encompass everything from minor surface erosion to catastrophic geotechnical failures. We recommend the addition of geotechnical before instability, and language tying such instability to movements sufficient to negatively impact existing infrastructure, to clarify that the rule addresses structural site failures rather than routine surface erosion, which is already regulated under the North Dakota Department of Environmental and Quality jurisdiction. Without this clarification, operators face uncertainty about whether every instance of surface erosion must be reported, creating potentially significant reporting burdens and deflecting North Dakota DMR resources from more serious issues. The permit application already requires operators to certify that locations are built in stable locations, and preventing erosion is already required as part of DEQ rules. Department field inspectors are notified of site construction commencement, so whether operators report stability issues proactively or inspectors instead discover them after the fact, the department will be aware of any problems. Adding the suggested language below, and you'll note that the additions are in green underlined, provides clarity and the necessary specificity to ensure appropriate reporting without over-reporting of routine maintenance issues. Moving on to Section 22, defective casing or cementing. NDPC supports the proposed change, allowing the department to receive reports of defective casing or cementing verbally, as opposed to a sundry notice being required in all instances. The Council also supports the proposed language regarding remedial work and diagnostics required to be submitted via sundry notice. This is a positive step in reporting clarity to ensure data is accurately included in the well file, allowing nearby operators to accurately assess the status of existing wells. Moving on to Section 27.1, specifically to subsection 3 in that section. The proposed amendment to this subsection concerning notification to the department in the case of an unexpected event provides broad notification requirements that may not be related to the integrity of casing strings and containment of stimulation and production fluids. The Council will request clarification regarding how the Commission defines, quote, other unexpected events, end quote. There is a legitimate need for operators to self-report fracturing operations that do not go as planned to protect future well operations, but the current language is overly broad. NDPC alternatively suggests amending the language to focus specifically on loss of containment issues. This revised language would provide the specificity needed to ensure appropriate reporting while avoiding confusion about what constitutes a reportable unexpected event. And you can see the proposed suggestions below in that subsection. Moving on to Section 28, Safety Regulation. The proposed amendment adds serious threat of injury to the environment as grounds for the director to order a well shut-in. NDPC requests clarification regarding this provision and raises several concerns. First, the phrase, quote, serious threat of injury to the environment, unquote, is subjective and provides no clear standards for when this authority may be exercised. The director already has authority under existing rules to shut in wells that pose threat to public health or safety. Lastly, environmental regulation in North Dakota is primarily the jurisdiction of the DEQ and not the Commission. This provision appears to expand the Commission's authority into environmental regulation beyond its statutory mandate for oil and gas conservation. NDPC requests clarification regarding what specific situations this provision is intended to address that are not already covered by existing regulatory authority. Current language stating, quote, threat of pollution, end quote, already appears to cover environmental concerns, making this change unnecessary in our opinion. Therefore, NDPC respectfully requests that this proposed rule be withdrawn. In the alternative, if evidence suggests additional shut-in authority is in fact necessary, the Council recommends the rule provide specific, objective criteria for when this authority may be exercised, appropriate notice requirements to operators, and clear standards for lifting shut-in orders. Any such authority should be limited to circumstances directly related to oil and gas conservation and well integrity, leaving environmental regulation to the Department of Environmental Quality. Moving on, Mr. Garner, to Section 29, NDPC strongly opposes the proposed amendments to this section with the limited exceptions of the addition of subsection titles and subsection 4302.03.29, subsection 2, requiring submission of existing GIS shapefiles for underground gas gathering pipelines placed into service prior to August 1, 2011. PHMSA regulates gas gathering lines as defined in API Recommended Practice 80 through its annual certification of the North Dakota Public Service Commission's authority to oversee intrastate natural gas pipeline safety. This certification is authorized under 49 USC Section 60105 and implemented through 49 CFR Part 192. Several provisions within the proposed rule appear to conflict with regulatory authority already delegated to the North Dakota Public Service Commission, particularly in areas such as damage prevention. The North Dakota Public Service Commission enforces damage prevention requirements under Administrative Code Chapter 69-09-03 and is the federally recognized state authority for intrastate pipeline safety. Moving on to subsection 1 of Section 29, dealing with notifications and proposed notifications. NDPC strongly opposes the proposed requirements in this subsection, which would require pipeline owners to provide extensive advanced notification and documentation for new underground gas gathering pipeline construction. The proposed requirements include notice at least 7 days prior to construction, verbal notification approximately 48 hours before commencing construction, submission of GIS shapefiles showing proposed pipeline routes, detailed design drawings including all associated above-ground equipment, pipeline specifications including size, weight, grade, wall thickness, coating, etc., testing methods, burial depth, road crossing information, and location of environmentally sensitive areas. These requirements all impose considerable administrative burden on midstream companies while providing very little discernible material benefits to the Commission or its oil and gas conservation mission. NDPC has identified multiple serious concerns with these proposed requirements, and I'll outline those below. First, dealing with administrative burden and impractical timing requirements. The proposed 48-hour advance notice requirement and automatic 1-year expiration of intent to construct notices create substantial operational challenges that do not account for the realities of gas gathering pipeline construction. Pipeline installation depends heavily on weather conditions, material availability, and landowner scheduling alignments, particularly for short segments of pipe installation that may be delayed or rescheduled on short notice. The 1-year expiration of intent to construct notices is particularly problematic given that easement agreements typically provide 2-year allowances for construction, creating a misalignment between regulatory requirements and standard commercial practices. Project teams and contractors would face considerable burden managing these notification requirements for what may be relatively minor pipeline segments, without any apparent corresponding benefit to resource conservation or public safety. We also have concerns related to duplicative data sets without clear purpose. The requirements to submit both intent to construct documentation in proposed subsection 1 and separate as-built documentation as currently required in subsection 2 creates multiple sets of data for the same pipeline segment with no articulated benefit. The Council respectfully requests clarity on what specific problem or problems these advance notifications are intended to address, or how the information will be used to further the Commission's oil and gas conservation mandate. The proposed language appears to be designed to require considerable data dumps to the Department for no apparent purpose other than having the data, which the Council does not believe is an appropriate basis for regulatory requirements that impose significant compliance burdens on the regulated community. From an operational standpoint, the data submission process and methods themselves have become overly technical and complex in other sections of the Administrative Code, namely in Section 4302.03.29.1, which currently mirrors the pre-construction notification requirements proposed in this section, though for oil and produced water gathering lines. Many operators report that the EGIS submission process has reached a point where only engineering staff can complete the process due to the intricate formatting, file editing, and shapefile management required. This level of technicality undermines the goal of regulatory transparency and accessibility and creates inefficiencies for both industry and department staff reviewing submissions. Moving on to our concerns related to data security and critical infrastructure protection. The proposed rules appear to contain no exemption or protection for sensitive pipeline locations and design data that is to be submitted pre-construction from public disclosure through FOIA requests or other means of information access. This creates serious concerns for asset security and integrity. Non-governmental organizations and other entities with interests adverse to oil and gas development should not be provided access to detailed plans on pipeline routing, specifications, and location data. As such, disclosure compromises environmental safety, personal safety, and asset integrity. Detailed infrastructure information in the wrong hands can facilitate intentional damage to pipeline construction projects and the pipelines themselves, creating genuine risk to the public safety and environmental protection, the very concerns the Commission purports to address through these regulations. Pipeline operators invest significant resources in protecting the security of their infrastructure information, and midstream companies maintain strict data protection protocols precisely because infrastructure vulnerability is a recognized concern. Requiring submission of this data to a state agency without adequate confidentiality protections and without a clear conservation-related purpose for collecting the information represents an unacceptable risk to critical infrastructure security. The Council respectfully requests that if the pre-construction notifications are codified, specific care will be taken by the Commission to safeguard critical data submitted in a manner similar to how as-built gathering line data is protected currently. Moving on to concerns related to undefined terms and landowner privacy. The requirements to identify environmentally sensitive areas suffers from the absence of any definition for this term. Environmentally sensitive can have many different meanings depending on context, and the lack of regulatory definition will likely create confusion and inconsistent application. More seriously, this vague requirement could result in the public disclosure of information about private landowners' property that landowners have legitimate interests in keeping confidential. Finally, our concerns related to existing infrastructure in place. The Council questions whether the extensive proposed notification requirements in this section are truly necessary given that thousands of miles of underground gas gathering pipelines have already been successfully constructed and operated in North Dakota under existing regulations. North Dakota is already among the most regulated states for gathering pipelines compared to other major producing states. The proposed additional requirements will impose significant administrative burdens on both operators and department staff without clear and demonstrable benefits to oil and gas conservation, environmental protection, or public safety. The Council strongly urges the Commission to withdraw subsection 1 of the proposed section 43020329 in its entirety. If certain information for specific conservation-related purposes is necessary to the Commission, we urge the Commission to clearly articulate those purposes and collaborate with industry to develop targeted requirements that address genuine regulatory needs while respecting infrastructure security, landowner privacy, and operational realities. Moving on to subdivision B of this section. The proposed rules require verbal notification of any line strikes during construction operation, maintenance, repair, or abandonment of underground gathering pipelines, including strikes of abandoned pipelines. This requirement appears to duplicate and potentially conflict with existing North Dakota Public Service Commission authority over pipeline safety and damage prevention. The Public Service Commission already has comprehensive processes for investigating and responding to pipeline strikes under its federally delegated authority. Adding a parallel notification requirement may create confusion about which agency has primary authority to investigate incidents, may result in conflicting directives to operators, and will not likely enhance safety. In addition to existing Public Service Commission and Industrial Commission jurisdiction, North Dakota already maintains a robust and comprehensive system for preventing and managing excavation-related damage to underground facilities through the North Dakota One Call program. The North Dakota One Call requirements are established under Chapter 4923 of the North Dakota Century Code and are administered and enforced by the North Dakota Public Service Commission. Under this law, any person conducting excavation must notify North Dakota One Call before digging, and operators of underground facilities must participate in the One Call system. North Dakota One Call functions as the state's official call before you dig program, designed to protect buried infrastructure, including gas gathering pipelines, from accidental damage. North Dakota One Call is not only a state requirement, but also operates under federal oversight through PHMSA, which establishes minimum standards for state damage prevention programs under 49 CFR Part 198. This dual state federal framework ensures that excavation damage prevention in North Dakota is governed by a unified, well-established system that already requires immediate reporting, coordination, and follow-up investigation of any line strikes or near misses. The Public Service Commission, under its PHMSA certification, retains exclusive authority for pipeline safety enforcement, including oversight of the One Call process and associated reporting requirements. As such, the Commission's proposed verbal notification requirements in Subdivision 1B is duplicative of and potentially conflicting with existing statutory and regulatory mechanisms already in place under North Dakota One Call and Public Service Commission authority. We strongly recommend that the Commission defer to the PSC's existing enforcement framework for damage prevention and incident notification rather than create a parallel requirement that would confuse operators, duplicate reporting obligations, and add no measurable safety benefits. If information about underground gas gathering pipeline strikes for purposes related to oil and gas conservation is deemed necessary by the Commission, this information can alternatively be obtained through coordination with the Public Service Commission rather than through duplicative reporting requirements imposed on operators. The Council respectfully emphasizes that North Dakota One Call already provides an effective, legally required, and federally recognized mechanism to prevent and respond to excavation damage. Leveraging this existing system rather than layering additional requirements would maintain regulatory clarity, promote interagency coordination, and continue to protect North Dakota's critical energy infrastructure. Moving on to subsection 2 of section 29. The Council does not oppose the submission of existing GIS shapefiles showing as-built locations of underground gas gathering pipelines, including those for pipelines placed into service prior to August 1, 2011. While the Council believes this information is of limited utility given existing pipeline mapping requirements and the considerable historical data gaps that will make complete compliance difficult for older pipeline systems, we recognize the Commission's interest in maintaining comprehensive records of pipeline locations for purposes related to drilling, permit review, and well spacing decisions. However, the Council's support for this limited documentation requirement is contingent on the Commission providing adequate confidentiality protections for pipeline location data. As discussed earlier, detailed infrastructure location info raises legitimate security concerns, and the Commission should establish clear policies limiting public availability of this data to prevent potential misuse by parties with interests adverse to the oil and gas industry or intent on damaging infrastructure. We note that the submission of GIS shapefiles for as-built pipeline locations is fundamentally different from the extensive advance notification design documentation and intent to construct requirements in subsection 1. Subsection 2 requires only final location data after construction is complete, which may assist the Commission in reviewing subsequent drilling permits and well locations to avoid pipeline conflicts. This narrow post-construction documentation requirement bears some relationship to the Commission's oil and gas conservation mandate, unlike the extensive pre-construction requirements in subsection 1 that serve no articulated conservation purpose. Moving on to section 29.1. The proposed amendments to this section impose new requirements on crude oil and produced water underground gathering pipelines. provisions, including a new pre-construction notification on the means to remove rocks from backfill material, notification of line strikes in instances where fluid is not released, and potential casing requirements for gathering pipelines crossing local or state roads. The Council acknowledges that, in general, North Dakota's gathering pipeline rules under Commission jurisdiction have been beneficial to both the state and the industry. However, both industry and the Commission now potentially face a shared challenge, an overly complex and administratively burdensome system that may no longer align with its intended efficiency or purpose. Under existing requirements under this section, the Department is inundated with data submissions while operators struggle to maintain compliance given the technical and procedural complexity of the current process. As I mentioned earlier, many operators have had to rely on their facilities engineers and not regulatory staff to complete submissions directly to the EGIS system due to the technical sophistication required. This dynamic creates unnecessary inefficiency for both the department and the regulated community, increasing the risk of inadvertent noncompliance despite best efforts on both sides. The Council believes that a collaborative effort following this rulemaking season to review and streamline crude and water pipeline reporting and data submission processes would serve the interests of both the department and the industry, improving data quality, regulatory efficiency, and compliance consistency. Moving on to subparagraph C. The Council believes the proposed addition under paragraph 1 of this section related to providing a statement on the presence of a means to remove rocks from backfill material to be unnecessary. Rules related to removal of rock from trench bottoms are already in place. And I made specific reference to the section of the Administrative Code that has that. Subdivision E of subsection 4 of section 29.1. Likewise, backfill material is required to be free of rocks greater than 2 inches in diameter in the construction phase. And again, that's in subdivision I of subsection 4. Notification that these requirements are planned to be addressed during the pre-construction phase is unnecessary and burdensome and contrary to regulatory efficiency. The Council therefore respectfully requests the withdrawal of the proposed amendment in this subparagraph. I'm moving on to subdivision A of subsection 3. The proposed rules require verbal notification of any line strikes during construction operation, maintenance, repair, or abandonment of underground oil or produced water gathering pipelines, with the addition of including strikes of abandoned pipelines, quote, regardless of any fluid release, end quote. As with the proposed rule changes in North Dakota Administrative Code 43020329, subsection 1, subdivision B, this requirement duplicates and conflicts with existing Public Service Commission jurisdiction over pipeline safety and damage prevention. The North Dakota PSC already has comprehensive processes for investigating and responding to pipeline strikes under its federally delegated authority. Adding a parallel notification requirement will likely create confusion about which agency has primary authority to investigate incidents, may result in conflicting directives to operators, and will not enhance safety. If information about underground oil or produced water gathering pipeline strikes for purposes related to oil and gas conservation is deemed necessary by the Commission, this information can be alternatively obtained through coordination with the Public Service Commission rather than through a duplicative reporting requirement imposed on operators. Moving on to section 29.1, subsection 4, subdivision F. The proposed amendment to this subdivision would grant the director authority to require casing of oil or produced water on underground gathering pipeline borings under roads for good cause. The Council finds this proposal to be problematic for several reasons. First, the proposed language conflicts with federal pipeline safety guidance. As documented in U.S. Department of Energy guidance, PHMSA specifically advises against mandatory casing requirements in many circumstances, recognizing that casings can create additional safety and maintenance issues. By allowing the director to require casing, quote, for good cause, end quote, the proposed rule creates a direct conflict with federal pipeline safety guidance, that may become even more problematic if and when North Dakota DOT or local road authorities decide to more heavily regulate gas gathering lines in the future. The term good cause is also vague and provides no objective standards for when the director may exercise this authority. This creates uncertainty for pipeline operators who cannot predict when casing requirements might be imposed during the planning and construction process. Current rules already require construction notification 7 days prior to commencement. Under the proposed rules, operators may theoretically learn only 1 week before construction that borings must be cased, making construction planning and project budgeting extremely difficult. Lastly, this is not an area where the Council believes the Department has traditional expertise or regulatory authority. Pipeline construction methods, including decisions about when to case borings, are properly within the jurisdiction of the Public Service Commission, operating under federal PHMSA authority. Local jurisdictions in the North Dakota PSC already have processes for addressing any unusual circumstances requiring special construction methods. The Council therefore strongly urges the Commission to strike the proposed casing requirement entirely and defer to industry knowledge and expertise and the existing Public Service Commission and PHMSA regulations on this issue. Moving on to Section 31. The Council supports the amendment allowing transport of crude oil from well sites before completion reports are filed, eliminating the previous requirement for verbal approval from the Director. This is a common sense change that recognizes completion reports are required within 30 days of initial production, while oil sales often begin immediately upon completion. The current practice has created unnecessary administrative burdens for both operators and department staff managing verbal approvals. The proposed amendment maintains accountability through timely completion reporting while eliminating an inefficient procedural step that provides no meaningful regulatory benefit. Moving on now to Section 48.1, dealing with commingling of production. The Petroleum Council strongly supports the amendment to remove the hearing requirement for diverse ownership commingling at central production facilities, allowing the Director to approve such applications without a formal hearing. This amendment represents exactly the kind of regulatory efficiency improvement that benefits both the industry and the regulating agency. Eliminating the mandatory hearing requirement for unopposed applications will significantly reduce administrative burdens and processing times while maintaining appropriate oversight through Director review and approval. The Council further recommends that the Commission ensure that commingling applications are reviewed promptly upon receipt and that operators are notified immediately if a hearing is required. The proposed rule language authorizes the Commission to place a CTB application on the hearing docket on its own motion, which, while understandable in certain circumstances, can potentially result in substantial and unnecessary delays. Providing prompt notice of hearing determinations would enable operators to plan and manage production timelines more effectively, improving operational efficiency for both industry and the regulating industry. The Council respectfully submits that the current language in proposed paragraph 430203 48.1 3B4 may unnecessarily trigger hearings in cases where the operator proposes a reliable and technically sound method for allocating production without a 72-hour test. Specifically, the rule still requires a hearing if the proposed testing duration is less than 72 hours, even if the method provides reasonably accurate monthly production allocations. We believe the Commission should retain discretion to approve shorter duration tests when the proposed methodology is sufficient to ensure accurate allocation of production. In many cases, modern measurement technologies and allocation models can achieve reliable results with less than 72 hours of testing. North Dakota currently has approximately 50 facilities approved for 48-hour allocation methods with additional operational conditions, demonstrating that shorter duration testing can provide accurate results when properly designed and implemented. requiring a hearing solely due to the duration of the test may create unnecessary administrative burden and delay for both operators and department staff. The council suggests revising this paragraph to allow the department to approve technically sound allocation methods with testing durations of less than 72 hours without requiring a hearing, provided that the operator submits adequate justification demonstrating the method's reliability. This approach maintains regulatory oversight and ensures accurate allocation while providing flexibility for operators to use modern measurement technologies and allocation methodologies that may not require 72 consecutive hours of testing. We also recommend that the department formally recognize in the rules that methods of allocation already approved by hearing are acceptable alternatives, as this would provide clarity and reduce the need for repetitive hearing processes for proven allocation methods. And then there is suggested language following below. Moving on to page 38 of the proposed rules, dealing with an addition of a subsection to 48.1. The council recommends clarifying and narrowing the proposed revocation language in proposed subsection 6. As currently drafted, the provision would allow the commission to revoke approval of a commingling agreement for violation of, quote, any terms, conditions, or directives, end quote, which is overly broad and could expose operators to revocation based on unrelated or minor compliance issues. Given the significant operational and financial implications of revoking a commingling agreement on a producing pad, the council suggests limiting revocation authority specifically to noncompliance with the commingling agreement itself. Broader enforcement powers already exist elsewhere in rule to address unrelated violations, making the proposed phrasing duplicative and unnecessarily expansive. And then there's suggested language following in green. Moving on to section 49, the proposed amendment adds oil vessels to diking requirements, but does not define oil vessel in the definitions section of this chapter. The council respectfully requests that this proposed amendment be withdrawn in its entirety. An oil vessel differs from an oil tank because the vessel is built to ASME code, which requires rigorous inspection, certified fabrication, and pressure testing. As such, it is able to withstand much higher internal pressure than an oil tank built to API's less stringent standards. Additionally, oil vessels have pressure safety valves for relief, as opposed to oil tanks that normally feature thief hatches that are more prone to leaks. The overall risk of failure, leak, or spill is much lower on an oil vessel compared to an oil tank. The council notes that the commission has traditionally allowed dike exemptions when perimeter berms and SCADA systems are utilized, and we request confirmation that this practice will continue. The rule requiring tank dikes to include volumes of, quote, 1 day's fluid production, end quote, has always been impractical when Bakken well sites first come online. As well as decline in production, however, the long-term facilities fit within the requirements. For frame of reference, the U.S. EPA requires containment to be 110% capacity of the largest tank or the largest tank plus freeboard. The EPA does not require this around oil vessels or flow-through process vessels. NDPC requests the Commission align containment requirements for these vessels with current EPA standards as described earlier and withdraw the proposed amendment in its entirety. Moving on to sections 52 and 52.1. The Council supports removing signature requirements for electronically filed reports, clarifying that reports are due by 5 p.m. on the due date, and clarifying that paper forms are no longer available, since North Star requires online submittal. These amendments align with the rules with current electronic filing practices and eliminate outdated requirements. Moving on to the proposed amendments to Section 81, NDPC supports the clarification that crude oil cannot be transported from a well or central production facility prior to approval of the authorization to purchase and transport oil form, and the provision allowing the director to verbally approve of the transportation of oil prior to approval of the authorization to purchase and transport oil form. This change aligns the rules with current operational practices and will improve efficiency for both operators and department staff. We recommend that the department prioritize making the authorization to purchase and transport oil form electronically accessible through Norstar to further streamline compliance. We also recommend that for bulk submittals, the department allow operators to submit one authorization to purchase and transport oil form with an attachment outlining purchasers, transporters, similar to the current Form 15 process, where one form is submitted with a detailed attachment for bulk submittals. Moving on to the proposed changes in Section 88.1, the Council supports removing central tank batteries and central production facilities from the list of hearing types that require formal proceedings, consistent with the changes to Section 4302.03, 48.1, and adding unopposed recovery of risk penalty applications to the administrative docket. These changes appropriately expand the Director's authority to approve technically sound, unopposed applications without the time and expense of a formal hearing. Moving on to Section 88.2. The Council generally supports the proposed amendments in this section, allowing hearing participation through remote communication aligns with current processes, modern technological capabilities, and common sense. The proposed amendments also eliminate antiquated requirements such as mandating a requesting party pay for remote access. We applaud the department for making this change to modernize hearing procedures. As an alternative to telecommunication throughout the proposed amendment, the Council suggests consideration of the phrase remote communication, which is a more modern, clear, and legally sound description that is used in many modern court and administrative rules, including federal and state rules of procedure. And then you can see how the proposed changes are highlighted throughout. Finally, moving on to Chapter 43.05.01, the proposed changes there. The Council has no objection to those proposed amendments regarding geological storage of carbon dioxide. These amendments appear to be primarily technical updates that provide clarity and align the rules with current statutory requirements. The Council supports the Commission's continued development of a comprehensive regulatory framework for carbon capture and storage projects, which may provide important economic opportunities for the state's energy sector while maintaining appropriate environmental protections. And with that, Mr. Gardner, I'd be happy to answer any questions the panel may have.
Any questions for Mr. Belton?
Brady, I just have a couple of questions to get maybe some clarity. On page 3 of your submission, the suggested language for this under the hydraulic fracturing rule, you had struck unexpected pressure loss occurs. Is that to be implied that it's suggesting loss of containment that's included in that?
Mr. Bohr, yes, that's correct. We view any unexpected pressure loss that may occur as an unexpected event. And I would suggest that including the suggesting loss of containment is an important parameter to kind of narrow that requirement down.
And on page 4 and the following pages, there's you made several references to the North Dakota Public Service Commission and PHMSA. The types of, these are the underground gas gathering pipelines. Are these lines that we're talking about here in this, in the administrative code, are they governed under PHMSA and the PSC?
Ms. Bohr, not currently. I think what these comments really get at is that there's potential for confusion over which jurisdiction is ultimately responsible for gas gathering line maintenance and construction.
So is there confusion out there right now?
Currently not, but I think bringing this into the administrative code would potentially increase that level of potential confusion.
And a little further down under notifications under 29, I think you may have referenced it later in your testimony, but this is essentially the same requirements for underground oil and gas or water lines. Is that correct?
Yes, Mr. Bohr, they do mirror the provisions of section 29.1. I think what we attempted to provide in our comments was just a general question: why are they necessary now, as opposed to 10 years ago when they were all being installed? What benefits does pre-construction notification to the department really provide? I think that was the general comment.
You made a couple of comments about the apparently technical difficulties in submitting the GIS shapefiles. Is that something that the Commission and the Petroleum Council can work on outside of the rule hearing process to see what those difficulties are and try to improve that if necessary?
Mr. Bohr, speaking on behalf of all of our membership, I believe that is very accurate. We'd be more than willing to come to the table and discuss how it can be improved.
On page 13 under 88.2, this is the telephone, telecommunication, remote communication rule. You say in here that remote communication is more modern, clear, and legally sound description that is used in many modern court and administrative rules. Can you provide an example of that for my benefit, of where it might be in a different, where it might appear in different administrative codes or court regulations?
Mr. Bohr, I can certainly get you some answers to that. I don't have any concrete examples off the top of my head right now, but I know that throughout, for instance, the Century Code, the remote communication is more of a standardized term, legal term for that type of communication involved in participation. But I'd be happy to follow up and get you specific examples of where that is.
Okay, thank you.
Anything further?
Brady, just one clarification for myself as well. On page 12, under your commingling, your purpose, or excuse me, your suggested language, it states the director may revoke authorization of commingle production in a central production facility for failure to comply with this section or any terms, conditions, or directed associated with this section imposed by the director. Why are you suggesting to state the same thing twice?
Mr. Tabor, I think that confining the failure to comply with the section itself is one thing, and then the terms, conditions, or directives I think that's a separate category that I'm not sure why it was in the original requirement in the draft proposed amendment, but we worked with that to further confine the terms, conditions, or directives to the provisions of this section.
Okay, so you're referring to it as anything added on or in addition to the original application, if you will.
Correct.
Okay, thank you.
Thank you, Mr. Pelton.
Thank you all.
Would anyone else like to make comment? Well, that concludes the. No. That concludes the Bismarck hearing for case number 32201.